Hi, this is me Arjun. Today I'll be reporting about termination of the contract by frustration. Throughout this report, I'll be talking about how contract can be frustrated under different circumstances, and I'll be taking one Australian case of the frustration of the contract, and I'll be analyzing that case through IRAC method, where I stands for issue and R stands for uh, throughout this report, I'll be analyzing Australian case of the frustrations with IRAC method, where I stands for issue, R stands for relevance, and A stands for application of that case, and C stands for conclusion. Well, there are several ways different contract can be frustrated. They are supervening illegality, death or illness of the either party of the contract, destruction of the subject matters, and common object no longer attainable, government intervention, and other supervening circumstances resulting in a radical differences in a performance. Case of termination of contract by frustration, I have taken one Australian case example, that is Goodall Construction Private Limited versus State Railway Authority of New South Wales. This case is from 1982, which was held in High Court of Australia. Commissioner for Railway New South Wales accepted tender which says Goodall Construction Company has to complete underground tunnel for the railway track from Edgecliff to the Bondi Junction. Later, Goodall started their work as mentioned. After a few weeks of construction work, local public and the local city council went against construction work, saying that it is creating noises and vibrations, and they request for the injunctions, and it is granted by court. Now, problem is that Goodall has to reduce their work shift and minimize themselves only up to 2 shifts in a day, and then they can work, and then they could work only and they could not work 10 p.m. to 6 a.m. and every day in a week. So that resulted in a delay in the work, and they could not finish their work within a given time mentioned in the contract. Well, let's talk about rules and relevant laws applied to this case. Rules of the discharge of the contract by frustration says a contract can be discharged by frustration when event is not completed by either party when contracting. It makes the contract fundamentally different from the original contract. Neither party is responsible or undertook responsibility for it. It leads to the situation where the parties would not have agreed to bond. Well, in this case, in a High Court of Australia, the majority of the judges considered that contract had been frustrated. Justice Brennan dissenting on the point. The question was whether the situation resulting from the injunction was fundamentally different from that contemplated by the contract. Based on the factual founding of the arbitrator, Justice Mason, stated in the paragraph 55 of this case, the performance of the contract in the events which have occurred is radically different from the performance of the contract in the circumstances which it constructed in the light of surrounding circumstances contemplated. Well, I have mentioned some other examples which are closely similar to this case. They are a change of the law makes performance illegal. It's a case of Reunion Limited versus Fraser, and another one is a party dies and becomes seriously ill or is called up for the military service and the contract requires personal service. Condor versus Baron Knights. And remedies for this kind of the case for common law is compensation of the loss suffered by the victim party. Here in this case, loss suffered by Goodall Construction due to the injunction issued by court, arbitrator is desired compensation. Well, let's talk about application of this case. In this case, as the law says, there is certain types of frustration because of injunctions. Company forced to change their work hours and workloads which later affected the performance and they could not finish their work in the time. Here, the injunction provided in the case was Frustration Act. Case was Frustration Act, which is not anticipated by both parties of this contract, and both parties will not take the responsibility of contemplated situation. This clearly matches the conditions mentioned in the rule of breach of the contract by frustration. Well, to conclude, a majority of the judges in the High Court on this case agreed grant of the injunction make it lawfully impossible to perform this job. So, in the pre-stated times, so situation becomes radically different and fundamentally different from that they undertake in the contract. So, this is the conclusion. Thank you so much for your time and consideration. Thank you so much.